couched in Wick-J-Encrel terms, leaving it to the courts to evolve necessary limitations. Our Constitution limited it by precise words of limitation, orig. Gopalan case referred to, when Article 368 speaks of changes in the provisions of the Constitution as arc, set out in ELS A to D of the proviso, it is manifest that the makers of the Constitution expressed their intention with unerring accuracy that FCA lures which can broadly be described as federal features, and from that point of view essential features could be amended. The proviso confers that power with relation to the judiciary, executive and the legislature, none of which could be said to be non-essential. The contention about unamendability of essential features do not take into consideration that the extent and character any change in the provisions of the Constitution is to be determined by legislatures as amending bodies under Article 368 and as representatives of the people in a democracy, and it is not the function of the courts to make any such determination. pp. 411, 412. The 24th Amendment made explicit what the judgment in Shankari Prasad and the majority judgment in Saja. Certain observations in Golaknath Raisky a doubt as to the meaning of the word amendment. The 24th Amendment has expressly clarified that doubt pure. Article 368 in the unamended term contained power as well as self-executing procedures, which if followed by the prescribed authorities would result in an amendment of the Constitution. The precise words 11 Constitution shall stand amended in Article 368 will exclude a simple repeal, that is, without substituting anything in place of the repealed Constitution. An amendment of the Constitution is an amendment of something which provides a system, according to which a state or a nation is governed. 414. An amendment of the Constitution is to make fundamental changes in the Constitution. Fundamental or basic principles can be changed. However radical the change, the amendment must provide for the mode in which the state is constituted or organized. The power of amendment is unlimited so long as the result is an amended constitution, that is to say, an organic instrument, one pro, vids for the making, interpretation, and implementation of law. First, under Article 368 Proviso, any limitation on the power of amendment alleged to be found in any other article of the Constitution can be removed. Secondly, judicial decisions show that by amending the article conferring the power of amendment, a greater power to amend the Constitution can be obtained than was conferred by the original article. Thirdly, the power to amend the amending power must include the power to add, alter, or lay CPCL any part of that article, and there is no reason why the addition cannot confer a power of amendment which the authorities named in Article 368 did not possess. PJL 5, 416, Ryan's case, 1935, Ir-Rep. 70 and Ranasinghe's case in 1965, AC 172. Referred to Kesavananda Bharati. If essential features could be amended by the people, the very fact that the Constituent Assembly did not include referendum as one of the methods of amendments and the fact that the Constitution makers excluded no part of the Constitution from amendment establishes that the amendment of a written Constitution can be legally done only by the method prescribed by the Constitution. If the method of referendum be adopted for the purpose of amendment, that would be extra-constitutional or revolutionary. The amending body represents the will of the people. Therefore, as long as Article 368 may be amended under Proviso any amendment of the Constitution by recourse to referendum would be revolutionary. The concept of popular sovereignty is well settled in parliamentary democracy, and it means that the people express their will their representatives elected by them at the general election. As the amending body prescribed by the Constitution, TJERC is intrinsic evidence in the provisions of Part 3 itself that our Constitution does not adopt the theory that fundamental rights are natural right or moral rights, which every human being is at all times to have. The basic concept of fundamental right is a social one and it has a social function. These rights are conferred by the Constitution. The nature of the restrictions on FMDAM central rights shows that there is nothing natural